The Supreme Court just heard arguments in a case that could change the gun rights of millions of Americans. If you live in Massachusetts, use marijuana legally and own a gun or want to own one, you need to watch this video right now. See, the case is United States versus Hamani. And I was watching that argument closely today. See, my impression, only one or two of the judges seemed even sympathetic to the government. The rest of the court appeared skeptical. And in some cases, they were genuinely alarmed by where the government's argument leads. This thing could be going down. So let me tell you the whole story. See, there's a federal law, 18 U.S.C. 922G3, that has been on the books since 1968. It says that if you are an unlawful user of a controlled substance, you cannot legally possess a gun. Federal felony, up to 15 years in prison. You've already heard of this statute. Hunter Biden was convicted under it in 2024. A jury found he bought a gun while addicted to drugs. Now the Supreme Court is deciding whether the law is even constitutional in the first place. See, here's the core problem. Marijuana is still federally illegal. It doesn't matter that Massachusetts legalized it. It doesn't matter that you bought marijuana legally from a licensed dispensary. Under federal law, marijuana is still a controlled substance. And under 922G3, if you use it and own a gun, you could be a federal felon. So how did we get to the Supreme Court? See, the FBI searched the home of a Texas man named Ali Daniel Hamani. They found a Glock, 60 grams of marijuana, and a small amount of cocaine. Hamani told agents that he smokes marijuana about every other day. He was indicted under 922G3, not for pointing a gun at anyone, not for being high while handling it, not even for not being licensed, just for being a regular marijuana user who owned a firearm. The district court threw the case out, and the Fifth Circuit agreed. They ruled that the law cannot constitutionally be applied to someone who was not actually impaired when they had the gun. The government appealed to the Supreme Court, and here we are. Now, before we get into the legal arguments, let's talk about who is on each side of this case, because the lineup could genuinely surprise you. On the government side, we got the Trump administration, 20 state attorneys general plus DC, Everytown for gun safety, and the Brady Center to prevent gun violence. So basically a bunch of gun control groups and the Trump administration and law enforcement. On Hamani's side, we got the NRA like you would expect, but we also have the ACLU, the Cato Institute, NORML, the New York State Rifle and Pistol Association, the Second Amendment Foundation. The NRA and the ACLU are on the same side. That tells you everything you need to know about how unusual this case is. It scrambles every normal political alliance completely. So now let's get into the legal meat of this. Here's what made 922G3 so dangerously broad for so long. Under the ATF's own federal regulations, you qualified as an unlawful user under this statute if you used illegal drugs at any point within the past year. One use, one positive drug test 12 months ago. Even just admitting to an officer that you smoked marijuana a while back. Under these regulations, that was enough to make you a prohibited person. Someone who cannot legally own a gun. Think about how sweeping that is. Tens of millions of Americans use marijuana. Half of the country has legalized it. And under those regulations, any of them could have been a federal felon for just owning a gun. Now, the government is before the Supreme Court arguing the statute should be read more narrowly. It only applies to habitual users, people who use drugs regularly and repeatedly. But there is a massive problem with that argument. And the justices today appear to notice it immediately. The word habitual does not appear anywhere in 922G3. It is not in the statute. Congress never wrote it. And the government needs to bring in a word into the law to make it constitutional. That is a serious signal that something is broken. See, it creates a vagueness problem that cuts right to the heart of due process. If ATF regulations say any use in the past year for decades, and now the government is telling the Supreme Court, no, it's actually habitual users only, how is an ordinary person ever supposed to know what the law actually makes illegal? How frequent is habitual? How recent? The government has not given a clear answer. That kind of legal fog is a constitutional problem on its own. On top of that, the government needs to satisfy the test laid out in the Supreme Court's landmark 2022 decision in Bruen. That completely changed everything for the Second Amendment. See, under Bruen, any restriction on gun rights has to be grounded in the historical tradition of American firearms regulations, going back to the founding. You need a real historical analog. You cannot just say, hey, drugs and guns are dangerous and call it a day. The government's best historical argument is that founding era laws treated habitual drunkards harshly. Vagrancy laws, civil commitment, surety bonds. So disarming habitual drug users today is just a modern equivalent of that tradition. But here's why that analogy falls apart. See, those old laws regulated behavior, specifically carrying or firing weapons while actively drunk. They did not permanently disarm someone just because they drank regularly. That distinction is everything. What 922G3 does is punish status, being a drug user, regardless of whether you were impaired the moment you possessed that gun. That kind of categorical status-based disarmament does not have a solid historical foundation. And the court today appeared to know it. Based on everything I saw coming out of that argument, I believe the most likely outcome is that the court affirms the lower courts and rules against the government, at least as applied to cases like Hamani's. The big question is how far the court goes. Now, they could go with a narrow ruling. They could say 922G3 cannot be applied to someone who is not shown to be impaired when they possess the gun. The statute survives the more extreme cases involving active addiction or being armed while drunk. Or the court could go with a broad ruling. Say there's no historical tradition of disarming people based on drug user status at all, and the statute gets gutted in most of its application. Now, that would be a seismic decision. We are watching closely because answer matters enormously right here in Massachusetts. Now, let me clear up one thing I want to get exactly right for you. The Massachusetts LTC application itself does not ask whether you use marijuana. What the application and state statute require is that you disclose whether you have a drug conviction on your record. That can be a permanent disqualifier. Or whether you've been under treatment or confined for a drug addiction, which can trigger a 5-year waiting period before reinstatement. The federal trap, though, it hits you more directly is ATF Form 4473, the form you fill out at the gun store every time you purchase a gun from a licensed dealer. That form asks you point blank, are you an unlawful user of marijuana or any other controlled substance? Now, if you're a regular marijuana user and you answer no, you may have just committed a federal crime, making a false statement on a federal firearms form. If you answer yes honestly, the dealer can't complete the sale. This is where 92G3 reaches into the daily life of Massachusetts residents most directly. Beyond that, Massachusetts police chiefs have broad suitability discretion when deciding whether to grant or deny an LTC. Drug use, even without a conviction, has been cited as a suitability basis for denial. A broad Supreme Court ruling that status-based disarmament of drug users lacks constitutional grounding would be a powerful weapon in appealing exactly that kind of denial. Now, the decision is going to drop probably later in the summer. The moment it does, we will break it down completely. What it means for your LTC, what it means for 4473, and what it means for Massachusetts residents living at the crossroads of state marijuana law and federal gun rights. Full blog post of the deep legal analysis is linked below. And if you have been denied a license to carry, or you have questions about how any of this applies to your situation, reach out to us. We represent people across Eastern Massachusetts on firearms licensing matters. Hit that subscribe button. You do not want to miss the follow-up when this decision comes down.